My name is Barbara Kalarjan, and I am the Director of Development of the Diocese of Rockville Center. Thank you so much for joining us today for our Legacy and Estate Planning Clinic webinar. We've created a PowerPoint for the program, which we will be showing on screen along with our webcams. To help minimize distractions and background noise, your cameras and mics are turned off. But we certainly would love to hear from you. So please submit your questions and comments through the Q&A window provided on your Zoom toolbar. We are recording this webinar and we will email you a link of the video as well as of the PowerPoint. Finally, after the conclusion of the program, and this is very important for us to help to serve you better, a brief survey will appear on your internet browser. So please take a moment to complete the survey and leave us your feedback. Now it is my pleasure to introduce Mark Henry, an attorney and a CPA. Mark has been working with us as a stewardship advisor on Catholic estate planning. Mark is the author of the book, Finish Faithful, which explains the important Catholic documents that you need to put into your estate plan that protects you, your family, and the future of our church. Thank you, Mark.
Thank you for that introduction, Barbara. It's a real pleasure to be joining you all today for this presentation. And we're going to be covering a variety of Catholic estate planning strategies. And we are fortunate to have some local attorneys joining us. Marie Puma from the Russo law firm is very experienced in estate planning. She's helped a lot of Catholics throughout New York with their estate planning strategies. And the focus really is going to be on educating folks about different alternatives and showing the ways that they can go ahead and implement some of these important planning strategies when it comes to their own priorities and planning. And so what I'll be doing is occasionally contributing here and there, but most of the discussion is going to be led by Marie. And we would ask that you hold your questions, for the end, but feel free to respond to some of the survey questions, which will be put in front of you that will enable you to, respond to some of the subjects in the presentation, but also have some questions that Marie will be able to address in a very general level at the end of the presentation. So without any further ado, why don't I turn things over to Marie at this point?
Okay, thank you. So good afternoon. My name is Elena Puma. I'm one of the partners here at Russo Law Group. We are going to have a wonderful program today with lots of information for everyone. And I invite you all to use the Q&A to send us your questions. And I also have some questions that you were kind enough to send to us in advance. So today we're going to go through what is a Catholic estate plan, what legal documents you should have, and how you can leave a lasting legacy. So how do you do this? So let's go through what these steps are. Okay, so we're going to look at Catholic estate planning. So for Catholics, doing estate planning and putting your affairs in order is an opportunity to provide for your family and to leave a lasting legacy. So you have to make sure that our Catholic faith is reflected in the decisions that we make in our estate plan and in those legal documents that we do. So there are 3 points I want to make here is that first, your plan should provide for your family members. As you know, as Christians, we have an obligation to remember our family and to make provisions to help them with their needs, right? Number 2, we should always honor our faith in God by being good stewards and following the Catholic teachings when it comes to our healthcare decision-making, our end-of-life decision-making, and our sacramental funeral wishes. And thirdly, we should always remember that we should support the Catholic Church and whatever Catholic organizations that are in our community so that we can include in our estate plan an enduring, lasting legacy wherein we always remember the church. Okay, so we're going to look at Catholic estate planning a little bit further. So when we look at Catholic estate planning, it's a plan of a faithful Catholic steward, which is a blessing to many and can include the following: sacramental wishes statement, Catholic medical documents, and an estate distribution which protects and provides for both our family and leaves a lasting financial legacy to the church. So that's what I just mentioned earlier. So now we're going to look at what these documents are. But before we look at the documents that are part of the Catholic estate plan, I want to talk a little bit about the Catholic truths and end-of-life healthcare. So you can see here, there's a listing, and I thank Mark for helping with putting this together, of all the Catholic teachings on euthanasia. So about end-of-life decision-making. So what I'm going to do, and I'm going to really look at my notes to cheat on this one, because I want to get it right. I'm going to summarize basically what these teachings say. So as Catholics, we see all these teachings. So we are so fortunate that the church provides us with guidelines about what we are called to do with regard to end-of-life decision-making. So in December of 2022, our bishop, John Barris, issued a directive obliging Catholic healthcare service providers to follow Catholic teachings on end-of-life matters. The writing locally implemented the United States Conference of Catholic Bishops 2022 publication, Ethical and Religious Directives for Catholic Healthcare Services. In this 2020 publication, the bishop stated that we are obliged to preserve life. If a person is hospitalized, they should not be denied life-sustaining care. A sick person should die from their illness, not because they were deprived of nutrition and hydration. They should also always be entitled to food and water, even if it's artificially administered. We also have the Samaritanus bonus, which is the United States Conference of Catholic Bishops Healthcare Services Directives, which was affirmed by Pope Francis in 2020. In this publication, which really focuses on the care of persons in the critical and terminal phases of life, it clearly stated that nutrition and hydration are ordinary and basic care and are necessary to maintain physiological functions unless there is no benefit to the body, which means that the body can absorb or metabolize the food and water and would actually cause harm. We also have the Gospel of Life, which is a landmark writing by Pope John Paul II, wherein he unequivocally condemned abortion and euthanasia and sharply challenged those who are part of the network of complicity that supports such crimes against humanity. So as you can see, the Catholic teachings are very clear and unambiguous. Euthanasia is not permitted. Food and water is basic care and obligatory and should always be provided. Even if the person is unable to do that themselves, we have to provide that to them artificially. Catholic teachings tell us we must respect, preserve, and promote life. We must keep this in mind when we put our Catholic estate plan together. So let's look at healthcare wishes. Ashley, if you don't mind, excellent. So our Catholic faith should be reflected in our decisions and all of our legal documents. We should follow the church teachings. We should have a Catholic medical directive that follows the church teachings. We should healthcare proxy that's consistent with church teachings. And we should have documents that do not promote euthanasia. So we're going to talk a little bit about living wills later, because a lot of Catholic people have living wills and they don't realize that that living will may promote or may be viewed to promote euthanasia. And that is certainly what, as Catholics, we do not want this legal document to say. So we have to make sure that these medical documents enable us to state our wishes concerning healthcare and end-of-life decision-making and make it very clear that we want life-sustaining care and relief from pain. All right, so what's the solution to this? The solution is for us to put into place documents known as advanced directives. And at this part of the program, I'm going to talk about those documents that focus on healthcare and end-of-life decision-making. Advanced directives are legal documents that we can put in place now while we're able to, meaning that we have the mental capacity and the ability to do that, where we can state what we want, what our wishes are, what our morals are, what our beliefs are, and what are the Catholic teachings that we all follow. So we're going to look at a healthcare proxy that talks about who has the right to make healthcare decisions. We're going to talk about Catholic medical declaration, which talks about how do you make sure your end-of-life wishes are carried out. And we're going to talk about the HIPAA authorization that entitles the appropriate person to access your medical records so that the proper medical decisions can be made. We're also going to talk about, and it's not on this slide, we're going to talk about the burial designation and the very important sacramental wishes statement. Okay, so we're going to go through those documents together. Now, we're going to start with the Catholic healthcare proxy. And a healthcare proxy is the legal document that you put into place where you appoint a person one at a time. You can have a successor, but only one person at a time who can make healthcare decisions for you. This document comes into play if you lack capacity and provides for ordinary care, including painkillers and assisted nutrition and hydration, because we know that these are tenets of our Catholic faith. Okay, in this document, you would direct your agent to make healthcare decisions according to the Catholic teachings on end-of-life decision-making. You would want to be clear that you do not desire any act or omission that will directly take your life. So I want to point out here, it also means omission, not just an act, right? So you don't want to be denied something that would result in your losing your life, and that you want to receive life-sustaining care, including intravenous nutrition and hydration. Okay, what you need to know is your healthcare proxy, the agent that you appoint, must act in your best interests. Okay, so that is why it is important that you clearly state what your beliefs are and that you want them to be in accordance with the Catholic teachings. And just as an aside, in New York State, if you do not have a healthcare proxy, there is something known as the Family Healthcare Decision Act, which was enacted in 2010. Unfortunately, it only applies to a patient in a hospital, nursing home, and to patients receiving hospice care who no longer have capacity and don't have a healthcare proxy. The act allows a patient's family member or a close friend to act as a surrogate to make healthcare decisions in that hospital, nursing home, or hospice setting. So it's very important that if you don't have this document, that you make sure your family knows what your wishes are, and that in that event, you would want them to follow Catholic teachings. All right. The next document I want to talk about is the Catholic Medical Declaration. And what you need to know is in New York presumes that you want life-sustaining treatment unless there's clear and convincing evidence as to your desires. So that is the good news, that in New York State, unless there's something to the contrary, you are going to receive all life-sustaining treatment, okay? But you still want to have clear and convincing evidence as to what your desires are. And that is why you should have a Catholic medical declaration, which will provide instructions to your agent, the healthcare proxy that we just spoke of, as to what your healthcare providers should, how your healthcare providers should treat you, and that you want it to conform with Catholic teachings, okay? So I want to talk a little bit about this medical declaration because it is intended to be what some people refer to as a living will, what I'll say a secular living will, but we don't call it that because a secular living will, as I mentioned earlier, could have provisions in it that are inconsistent with Catholic beliefs and could actually be viewed to promote euthanasia, okay? So you don't want to have a living will. You want to have a Catholic medical declaration. So I just want to make sure that you are clear on that. So let's look at what a Catholic medical declaration states. It states that you want to receive ordinary care. You want to receive food, water, and you want to receive medically assisted nutrition and hydration, like through an intravenous. You want to preserve your life. You want to exclude acts or omissions of euthanasia or suicide. You want to receive the healing sacraments, reconciliation, anointing of the sick, viaticum, apostolic pardon. So this is be very, very clear of what you want. This is not what you see in a secular living will. So I just caution everybody that if you have these documents, that we have to take a look at those closely. Now, it just occurred to me that I wanted to do a polling question, and for some reason, it didn't come up on the screen. So at this moment, I'm going to ask Ashley before we move on to the next part here. Ashley, are you able to reactivate that poll? Thank you very much. Okay, so we have it now. So I want us to have a little fun with this program today. So you will be able to, on your computer, answer this poll. So I would like you to let us know if you have any of these legal documents: healthcare proxy, Catholic medical declaration, living will, HIPAA authorization, burial designation, sacramental wishes statement. And I believe we had a category, Ashley, for none. Is that showing up? Looks like everybody on has to at least have something, because they're not sending none in. So we'll give it a couple more seconds. Ashley?
Yeah, Maria Elena, we do have it's at the very bottom. If you scroll, there is a none. So it looks like
Okay,
about
I can't-
45% so far.
Okay, oh, I got it now. I had to open it up on my screen. So, all right. So not as good as a result as I was hoping, because there's 45% with a none. And I'm just glad we got this poll started, because this is helpful to us. All right. So we'll give it a couple seconds, and then Ashley, let's end the poll, and then we'll see. So it looks like
I myself will be very curious about the results here, Marie,
Yeah.
because working in the field of estate planning, you probably have some overall understanding as to what percentage of people don't have any estate planning.
Yeah.
And so our poll perhaps will shed light on, the people who attended the webinar, and, what percentage of them don't have any estate plans in place. So this will be an interesting survey.
Yeah. So, I mean, this survey is interesting. Unfortunately, we only have 26 people responding to it, but I mean, that's a good amount. So we've got just about half of the 46% of everybody, of the pollers, have a healthcare proxy. Nobody has a Catholic medical declaration. Okay, so that is something I'm glad that we're talking about today. 11 of you have 42% have a living will. So I'm going to ask you again to look at that closer to make sure that it is consistent and not inconsistent with Catholic teachings. HIPAA authorization, 23% of you. We're about to talk about burial designation, sacramental wishes statements, and durable power of attorney, but we can see ahead of time here. Only 8% of you, 2 of you have a burial designation. Nobody has a sacramental wishes statement. So Barbara, when we get to that later, we'll talk about that in detail. I know you have a sample form for that. And power of attorney, we have about 31% of you, 8 of you. And then we've got 12 of you, 46%, who have none of these documents, not even a single one. So that's why we're here today, to show you why you need to act, take control, and put a Catholic estate plan into place. Okay, so I'm going to stop sharing on this poll, Ashley, if we can get that off the screen now. I'm trying to, how do I get back, Ashley, to my screen? It's not letting me come back. Or you're controlling it?
Do you have the exit, the close button at the top right?
Yeah, okay. I just didn't want to undo it. Okay, so we're back to the slide.
Okay.
All right, so we just talked about the Catholic Medical Declaration. And again, I'm going to keep this up here for another second, because nobody has one of these So, and those of you that have, I think 11 of you have a living will. Your living will, look at it closely. I can't impress that upon you enough. You want to have ordinary care, food and water, even medically assisted, artificial nutrition and hydration. You want all acts that will preserve life. You don't want any acts or omissions that will cause euthanasia or suicide. And you want to receive the healing sacraments, okay? All right, so now we're going to look at the HIPAA authorization. And I'm sure many of you are well aware of HIPAA authorization. When you go to the doctor's office, you probably sign one all the time to get medical records to be released. This is a more detailed document that allows your healthcare agent to access your healthcare information so that your healthcare proxy can make the most informative decisions about your care. Okay, so HIPAA authorization is an important document for your healthcare decision making. The next document I want to talk about is actually called the appointment of agent to dispose of remains upon death. It's also called the burial designation. So Ashley, if you could change the screen for me. Okay. So in New York, we call it a burial designation. This is a document that will allow you to name an individual to be in charge of your burial arrangements. You can provide within that document specific instructions about your funeral or your burial. A lot of times I will see that people put this information in their last will and testament. And I just want to point out here and tell you that is not a wise decision, because usually a will is not even seen or offered for probate until after you have passed away and until after the wake, the funeral, all these decisions would have had to be made by that time. So having it in your will is not going to be helpful. Because your will is not legally enforceable until it's probated, which will occur after these decisions need to be made. So it's very important to have this burial designation. And what goes along this is what I'll call the Catholic component of the New York State burial designation. And that Catholic component is known as the sacramental wishes statement. And sacramental wishes statement is something that I'm going to say priests love and families love, because it's a very, very informative document. It makes sure that your wishes for a Catholic funeral are carried out. It is very clear about what you want. So, for example, it will state the name, the telephone number of your parish priest, so that your family can contact your priest or a friend, so that you can receive the healing sacraments, so that you can receive reconciliation, anointing of the sick, viaticum, an apostolic pardon if it's determined that you're likely not going to survive, that a family member or friend with will assist with faith-based matters, such as your vigil and your funeral, the directions that you want for your Catholic funeral, including the location of the vigil, special prayers, your eulogy requests, the funeral mass details, who's going to participate, who's going to be readers, what's the scripture going to be, what are the burial details. So this is a very, very, very informative document. It also includes, if you want, a request for offering masses and other faith-based matters. So this sacramental wishes statement goes well beyond the New York burial designation and provides all of this information to the person who's going to be making those decisions for you. And I know there is a sample that Barbara has provided to me that is the sacramental wishes statement that provides kind of like a fill in the blank type of format. And Barbara, would you be willing to share that with anybody who would be interested in seeing that document?
Absolutely.
Okay, so if anyone's interested, just let us know and we will arrange for Barbara to share that document with you. All right, so that kind of covers the healthcare end-of-life decision-making aspect of a Catholic estate plan in terms of these advanced directives that you can put these legal documents in place. I just want to mention, well, what happens to finances? What part of my Catholic estate plan will address managing my money, paying my bills if I'm not able to do that, managing my assets. So it's very important that you have what's known as a durable power of attorney, which will allow you to appoint a person or persons who can act either jointly or separately to handle financial matters for you, okay? So it's very important to consider having this document and outlining comprehensive powers. These powers could go from bill paying to asset management, to signing tax returns, to dealing with the IRS, to dealing with Social Security, to arranging for delivery of your mail. So there's all kinds of powers that can be drafted into this power of attorney. Okay, again, this talks about financial decision making. You can appoint multiple agents, you can appoint successor agents, and what you need to know is under New York law, your agents must act within your best interest. Okay, so it is very important for you to have a legal document such as a power of attorney to be able to handle financial decision making. So this is another form of advance directive. And I just want to point out again, the importance of executing these advance directives at a time when you have the mental capacity to do so. Because should you not have these documents in place, your family would then have to commence what is known as a guardianship proceeding, and to go into court and ask the judge to appoint somebody to be your person to make healthcare decisions and to make financial decisions for you. And you want to make sure that you're in control, and you do that now so that you can ensure that the people that will be appointed will follow your Catholic estate plan. Okay, so all of these documents, the healthcare proxy, the Catholic medical declaration, the HIPAA authorization, the burial designation, and the sacramental wishes statement are advanced directives, and you have to put them in place to ensure that your Catholic beliefs will be followed. All right, we're going to have some more fun again. We're going to do another poll. All righty, so let's see if we can get this second poll up. All right, so this one's short. Do you have a will? Do you have a revocable living trust, or do you have none? So we're going to open the poll now. Give it a couple seconds. All right, I think we may have had. All right, we have 28 people answering. And Ashley, I think we can close this poll. All right, it looks like we've got 61%, 17 out of 28 of you have a last will and testament, so that's wonderful. And 14% of you, 4 out of 28, have a revocable living trust. That's great as well. And 10 of you, 36%, do not have either. So that's not good, because you, again, one of the things that I am talking about through this program today is your being able to have control so that you can ensure that you have a Catholic estate plan, and that you're and that you're going to appoint the people who are going to enforce that is Catholic estate plan for you. So when you leave it up to New York State because you don't have these documents in place, you're not going to guarantee that your wishes will be followed. Okay, so we're going to stop sharing this and go back to the slide. All right, so I asked about these documents, the last will and testament and revocable trust, because now we're going to turn to what happens when you pass away, right? Because everything we spoke about up until now is the part of your Catholic estate plan that has to do when you're alive, right? So now let's talk about your Catholic estate plan when you pass away. So how are assets accessed to pay for your funeral? Who's going to be overseeing the administration of your estate? What if your will has to be probate? How long does that take? So I'm going to talk about some of these issues with you. But first, I want to talk to you about assets. And I want to point out that there are two types of assets that people own. And I'm not talking about a bank account or real property. I'm talking about the way they are legally titled. And those are what's called a probate asset and what's called a non-probate asset, okay? A probate asset would be an asset that you just own in your name alone. So it would be a bank account in the name of Maria Elena, right? There's nobody else on that but me. That's an example of a probate asset. So if I were to die, then my will address probate assets, assets that are in my name alone. Okay, so anything that's in my name alone is going to have to go to my beneficiaries in accordance with the terms of my will. A non-probate asset is an asset that is titled in the name of a revocable living trust, for example, or maybe a joint account owned with my spouse. So it would be Maria Elena and Michael, joint tenants with rights of survivorship, or an IRA or a life insurance policy designating a beneficiary, or a brokerage account that is called TOD, transfer on death, or savings bonds that are POD, payable on death, or even a bank account that's ITF, in trust for. So those are all examples of non-probate assets, which means that they pass automatically by operation of law to the other person on that account or that beneficiary named. And you do not go to court, and it does not pass by the terms of your will. Okay, so a lot of times people get confused because they don't realize that you could have assets that are going to fall under your will and assets that are going to fall under a trust or pass automatically. All right, so I'm going to talk a little bit about a will first. So Ashley, if you don't mind going to the next slide, and then we're going to go back to that prior slide. So what is a will? A will provides for the administration of your estate and the orderly disposition of your assets upon your demise, meaning you are deciding who is going to be your executor, the person who will enforce your will, and you are going to decide who receives your assets, okay? A will must be executed with proper formalities in New York State. You can change your will by writing on it, just so that you know. You can't handwrite a will in New York. That's a general rule. There are exceptions for times of war, for somebody in the armed services, or for mariners at sea. But generally, you need to have your will in writing, meaning a printed form, not a handwritten will. And if you don't, what happens? Well, if you don't, New York State says who's going to be in charge of your estate and who's going to receive your assets. So that person is called an administrator instead of an executor. And then there's a pecking order that New York says, well, your wife will, or your husband will get so much and your kids will get so much, and then it will go down and so forth. You don't want that. You want to be in control. You want to pick the person that will enforce your estate and who will distribute the assets in accordance with the terms of your will. And you will determine who you want those beneficiaries to be. You also could put in your will certain contingency provisions that will allow for, a supplemental needs trust if for some reason you have a beneficiary who's receiving a government benefit like Medicaid. So there are better ways to provide for how your assets will be transferred to your beneficiaries than leaving it up to New York State, which is known as intestacy. Okay. I'm going to go back to the prior slide, if you don't mind, Ashley. I'm going to talk about a revocable living trust. This is an alternative to a will. It avoids probate. And what I didn't mention before about a will, and I said it earlier, is that the will has to be offered to the surrogate's court to be validated, basically, and to be admitted to probate, and then it can be enforced. That probate process can take several months. The courts are still backlogged from COVID, and they're taking, like in some counties, well into 6 months to get an executor appointed. And that's a problem, because then how does somebody get access to assets, to pay bills, and to do things while this is pending in court? And that is why there are alternatives. We talked about before, alternatives are having beneficiaries designated on some assets, and owning some assets jointly, like real property. But another alternative is what's known as a revocable living trust. And a revocable living trust is another way to avoid probate. And you establish that during your lifetime, and it is just that. It's revocable. Just like a will is revocable, you can, during your lifetime, you can change your will as many times as you want. This revocable living trust will have the same provisions as a will. Instead, you're going to appoint a trustee instead of an executor, and then you're still going to have the provisions about who will be your beneficiaries. The different issue is that the trustee does not have to go to court when you pass away to be appointed. The trustee can act immediately upon your passing. The key here, though, is that you have to make sure that you fund your revocable trust during your lifetime. And what does that mean? That means that you have to transfer the title to your assets into the name of the trustee of the revocable living trust. So, for example, your real property would be the, I'm going to use myself as an example, so-and-so as trustee of Maria Elena's revocable living trust, okay? And as long as the assets are transferred into that trust, you can avoid probate. I can't tell you often that I meet with children whose parents pass away and they say, oh, we don't have to probate because my parents went to an attorney and they did a revocable living trust. And I say, that's wonderful. And then we start looking at the statements for the brokerage account and the banks, and we look at the deed to the house, and we realize that it's still in the mother's and father's names because they never moved the assets into the trust. Okay, so that's something that's very important, that if you're looking for a way to avoid probate, that you make sure you fund that trust. All right, so we're going to skip ahead to 2 slides. And I want to just talk about 2 other trusts. And I put this in here because some of you were kind enough to send some questions in advance. And somebody did ask about a Medicaid trust. So I wanted to spend some time speaking about a Medicaid trust. So we call that a Medicaid Asset Protection Trust. And unlike a revocable trust, a Medicaid Asset Protection Trust is irrevocable. Okay, so it is totally different. It's not something that you can change. The purpose of a Medicaid Asset Trust is to provide for long-term care, which we all know can be very expensive, especially if a family member needs care in a nursing home, right? So, and we all know that unless we have long-term care insurance, that Medicaid is the only government program that provides for long-term care, right? But there's financial eligibility requirements. Unlike Medicare, which you can automatically qualify for, right, at age 65, Medicaid says, no, we're going to look at your assets. We're going to look at your resources. We're going to look at your income. So you need to figure out a way to try to protect some of your assets if you should need long-term Medicaid care in the future. And we always tell our clients to think ahead, right? Try to do these things when you're well and when we're not looking at the need for Medicaid in the near future. And the reason for that is Medicaid has what's known as a look back. So Medicaid will look back 5 years to see if you transferred any assets. Now, I say Medicaid for a nursing home facility will look back 5 years. Currently, even though they're looking to change the law, there is no look back period for community care, home care Medicaid. So basically, once you put the assets in this trust, after 60 months, that asset is protected and will not go against you for Medicaid eligibility. Okay, so that's something that's very important to look at. So if you're thinking you're well now, but you don't know if you might need Medicaid in the future, you should consider to start to protect some of your assets. Now, what I see mostly, not mostly, but more often, is that clients' biggest asset is their home, right? So they come in and they say, I want to do Medicaid Asset Protection Trust. I don't want to do anything yet for my liquid assets, but I want to start to protect my house. And they transfer the house into that trust. The trust provides they still have the right to live there during their lifetime. And that upon their passing, it would go to their children or whomever. But that is what a Medicaid Asset Protection Trust does. And after 60 months, the asset in there, presumably the house, would be protected. All right. I also want to just mention one other type of trust, which we call a family protection trust. And that is a trust that you may want to set up for a beneficiary who may have some type of, I'm going to say, special needs. For example, maybe they're having marital problems or creditor issues, or maybe they, God forbid, have a drug and alcohol problem, or maybe they're spendthrifts. This would be a way to still provide for that family member, so that they're not disinherited, but it's in a protective way. So it's going to be held in a trust with a trustee who can then control the monies for that beneficiary. Sometimes you see that with what's called a supplemental needs trust for when you have a child, say, with a disability or special needs. All right, we're going to go to our last polling question. And that is question number 3. Would you like to leave a lasting legacy to the church in your estate plan? So this is simple, a yes, no, or maybe. And we'll just give it a couple seconds longer. I think we have about 28 people, so we're at 25. I think we're 26, we're getting close. Okay, it looks like we're there. Ashley, we can close the poll. Oh, no, we have 29. We have somebody else who joined us. All right, I think we're good. We can close the poll. So we have yes, 21% of you, 6 out of 29. No, 11 out of 29 of you, that's 38%. And a maybe, 12 out of 29, 41%. Okay, so I'm going to talk to you about legacy planning strategies. And it doesn't have to be just to the church. It could be to any charity. If you're interested in being, philanthropic in some way. So I'm going to call this legacy plan gifts. I'm going to focus on 3 of them. One is gifts from wills or trusts. And those can be gifts where you provide in your will, I want to leave $20,000 to the Catholic Church, or that could be in your trust. Or it could be an appreciated asset like a stock. So it's basically a gift that you're giving after you pass away. This is a future gift. I'm not talking about gifts that you make during your lifetime. This is legacy planning for you to, as part of your Catholic estate plan, for you to provide for others, for the church, to give back what you've had, the benefits and the blessings that you've received during your lifetime, and to share and to support the church or another charity. So you could do that again in a will or a trust with a specific bequest for a monetary amount or a specific asset. It could be a piece of real property, and that would occur upon your passing. Another way would be through an IRA, or an insurance policy, and we're going to look at that a little bit more closer. And the other one is a QCD, which is a qualified charitable distribution from an IRA or a retirement account. We're going to look at that closer. And the beauty of looking at some of these strategies is, one is that you can revoke it if you change your mind. It doesn't happen in the future, so it's really not affecting you now and your current lifestyle. And there can be some tax benefits to it. All right, so let's look at the first example. So this one has a good tax benefit. This is a gift of an IRA to a charity or to the church upon your demise. So the way this works is you just designate the church or the charity as the beneficiary on your IRA. It's a simple form. You contact the financial institution and you designate, you could have your spouse first, and the contingent beneficiary would be the church or your parish or a different charity. This avoids income tax that would otherwise be payable if a non-spouse family member inherited the IRA. It also applies to the spouse as well. And what I'm getting at is, as we all know, there are required minimum distributions. So an IRA is income tax deferred during your lifetime. But when it starts paying out to the beneficiaries, they have to take out the required minimum distributions. And they have to declare that as income, right? So if you leave the IRA to a family member and the IRA is worth $10,000, after they pay taxes, they may only see $7,000, right? That's just an example. If you were to leave that IRA to Catholic church or a charity, there is no income tax consequences. They will receive the full $10,000. So you may be better suited to leave a $10,000 bank account to your family member that's not income tax deferred and won't create an income tax, and leave the IRA asset of $10,000 to the charity. Okay. And it could be part of it, of the IRA. It could be all of the IRA. It depends on, what your intentions are. But again, you don't have to make this gift until after both you and your spouse pass away. You could also do this with life insurance. You can designate, say, your spouse as the beneficiary in your life insurance policy, and maybe the charity or the church as a secondary beneficiary in case your spouse predeceases. So it's very easy to designate the church as a beneficiary. The other thing I want to talk about with an IRA is the qualified charitable distributions, the QCDs. And this is when an individual who is at least 70 and a half, you can donate up to $100,000 from your IRA annually as a QCD, a qualified charitable distribution. Well, what does this mean? This means like every year you have to take your RMD, your required minimum distribution, and you have to pay income tax on it. You can instead take all a part of that, and it counts as taking your RMD, and instead you can give it to a charity or the church in an amount of up to $100,000. It's not considered income to you. It counts as taking your RMD to the extent that you gave it to the charity, and you're doing something good, and you're not paying tax on that, and the charity is getting some money sooner than later. What you also need to know about this is that if you're married and you file a joint return, both spouses are entitled to give up to $100,000 from their IRA as a QCD. So these are just some ways that you can save taxes by doing something good and following your Christian values and the teachings of the church to help your community. All right. So what do you do now? How do I implement my Catholic estate plan? You need to take control. I mean, that's what I can tell you. You need to do it. Stop thinking about it's something I'm going to do tomorrow or something I'm going to get to, but get to that plan. Take control, get your advanced directives in place that we talked about. Look at a will, look at a trust, figure out what works best for you. Look at your assets, see how you own them as probate or non-probate. Consider making some charitable contributions. Consider maybe naming a charity as a beneficiary on an IRA or a life insurance policy. Think about living your Catholic faith and leaving your legacy. Okay, so that's the formal presentation. What I want to do now is get to some of the questions that we have. It looks like we've got several of them. So the first question I have here is there a tax advantage way to donate directly from an IRA? Well, we just looked at that, right? So you can definitely designate the charity or church as a beneficiary of an IRA for when you pass away. And that avoids a piece of the IRA going to income taxes. And you also can use some of your RMD up to $100,000 to make a QCD donation during your lifetime to the church. Number two, what are the benefits of having a trust in addition to a will? We addressed that also. You can avoid probate. So there may be some assets that pass under your will that take longer to get to because you have to go to court. But the revocable trust assets are there and immediately accessible upon your passing. But again, you have to make sure that you fund that trust. Number three, are there Catholic pro-life healthcare documents that protect me and my spouse? Absolutely. We looked at those. A Catholic healthcare proxy, a Catholic medical directive, the burial designation with a sacramental wishes statement. So those are definitely documents you should have. Number four, how do I put a home and second home in a trust for my children? So those are done, assuming you have those trusts, those are done with a deed transfer. You have to transfer title to the name of the trustee of your trust and fund it into the trust. Number five, what opportunity is there to transfer? I'm reading it verbatim. What opportunity is there to transfer house to diocese, but retain to reside until death of husband and wife. Okay, so I'd have to know more about what your circumstances are, but basically you have a couple of options. We talked about you can have a request devised. It's actually called in a will for real property. So you could say upon the passing of both your husband and wife that the house passes to the church. You can actually, that's one way. Another way is you can transfer the house into a trust, a revocable trust like we talked about, and have a provision in the trust that says upon your passing that of husband and wife that it goes to the charity. Another way would, I don't know that I would recommend it without knowing your situation, would be to transfer your house to the charity, to the church now and retain a life estate for you and your wife in that, but in the house. But again, without knowing the circumstances, I wouldn't recommend anything specifically. You have to look at what ways do you get an increased step up in basis, like by retaining the right to live there. So there are tax consequences that you have to look at as well as your personal situation. Number 6, explain different types of trusts. What is the best trust to protect assets, i.e. in view of Medicaid look back? So we talked about that before. That's the Medicaid Asset Protection Trust. Number 7, can a credit card attach a self-directed trust? I don't understand this question, so I invite whoever sent this question in to send an email to Ashley. You have her email address, and we can try to get you an answer for that. Number 8, is a will sufficient enough to pass your home onto your child in the event that a husband and wife should die within close dates of each other? So you both should have wills, and the will can provide that upon the death of both of you, the house goes to your children. The will, assuming that you own your property as husband and wife as tenants by the entirety, it would pass to the surviving spouse after the first one dies, and that person's will would be the will that would be probated to pass it then to the child. Number 9, my wife and I are considering to transfer the title of our house to our 3 children in order to avoid probate. What are your thoughts and recommendations? My recommendation would be then to do it in the form of a revocable trust or a Medicaid Asset Protection Trust, depending on what your circumstances are. Number 10, I have a will. My wife died, leaving my son on the deed. Since I have a will, do I need a living will to avoid probate? So I think in this question, you're confusing what is a last will and testament with the living will, which we talked about is a document that often promotes euthanasia and not providing nutrition and hydration. So I invite this person as well to send an email. But if I kind of try to read through this question, the answer is, as long as your will provides that your son inherits the house, then the will would be probated and it would pass to your son. Number 11, my mother was forced into selling her house and has the proceeds in a trust. If she bought a condo, would it go into the trust? So the first part of that question is, I'm going to assume that the house was already transferred into a trust and then sold by the trustee. And if that's the case, yes, the funds would remain in the trust, and then the trustee would buy the new condo in the name of the trust for your mother. Okay, and then she said, just a comment here, she also doesn't have necessary income to take out a mortgage and wants me, her eldest daughter, to take it out. I'm not sure what the question is there. Okay, number 12, may I use a formula, for example, fraction over percentage, to set the charitable amount? This is a good question. You can do whatever you want in your document about what you want to leave to charity. My suggestion, though, is, if possible, to make it as simple as possible. And I say that because if you know that you want to leave the charity the church X dollars, so let's just say $10,000. I prefer that you say I leave the church $10,000 rather than a formula. And the reason why I say this is when you give to a church or a charity in your will or your trust, anything other than a defined amount Like, so if you gave a percentage, I give the church 25% of my estate versus $25,000, the Attorney General of the state of New York gets involved, and it becomes a much more complicated process to administer your estate or trust, because you'll have to submit an accounting to the Attorney General, because they're going to make sure that the charity received exactly what they were supposed to, right? Because they don't get involved. If the charity's supposed to get $10,000, then that's $10,000. But if it's 25% of your estate, the Attorney General needs to look to see how did that calculation occur in terms of the administration of the estate. So if possible, I would give a defined monetary amount or a specific asset, like a piece of real property or a specific account. Number 13, may I designate somebody to select designate somebody to select after I die the charitable recipients? So a good question. Again, here, I always suggest that if you know who your charity is, that you should make it clear. We can put provision in a will or trust that if that charity is no longer in existence, then your trustee or executor can have the power to find a similar charity with a similar purpose and like causes. But my suggestion is to always name a charity that you have in mind. All right, now we've got 5 more questions, I think. Yes, so those were the ones that were sent ahead of time, and the following are the ones from the Q&A. So we got about 3 minutes here. Okay, number 1, does a living will have by itself full legal effect like a healthcare proxy, or is it up to the discretion of the agent to comply literally with the living will provisions? Okay, so I think the question here is, is that in New York, we have a statute that actually allows for a healthcare proxy, and we do not have a statute for a living will that's based upon case law. Both are legally enforceable. Okay, next question. Can an individual have both a revocable and irrevocable trust that each will handle different assets by different trustees? Yes, you can have a revocable trust for certain things and an irrevocable trust for other things. You could have different trustees in both. I just caution you to just try to be clear when you put your estate plan in place that, sometimes it's better to have one person or co-trustees in charge if you have varying assets, because you want to make sure you have somebody who really knows everything about your estate plan. Where can we get all these forms, and would you speak at a parish? Legal documents have to be drafted by an attorney. The sacramental wishes statement is something, and correct me if I'm wrong, Barbara, that the diocese has created.
Yes.
So Barbara can share that with you. And would we speak at parishes? So we're working, and Barbara can talk to that maybe at the end of the program a little bit about that. Next question, do QCDs from an IRA count against you for the Medicaid look back period? So very, very good question. Yes, anything that you do in terms of transferring of an asset or an income is looked against you for Medicaid. So Medicaid and the Medicaid laws and the tax laws are not the same. So for another question I often get is, well, if I only make the annual exclusion gift of $10,000, that's not a taxable gift, so Medicaid shouldn't look at it. The answer is no, it doesn't matter. Medicaid looks at those transfers. Next question. You have discussed a revocable trust. Is there any advantage to an irrevocable trust? Yeah, sure. As we talked about before, it depends what your plan is and what your goals are. An irrevocable trust is very important if you're trying to do long-term care planning to protect assets. It also avoids probate, but the main goal of that is long-term care planning. A revocable trust doesn't protect assets for Medicaid. It solely avoids probate. Okay. There are also revocable trusts that you use and irrevocable trusts that you use for estate tax planning. Obviously, that's not for today's program. So there's advantages for both in different varying situations. I think that is it. And it's 3:00. So I'm going to turn it over to you, Barbara.
Thank you so much. I'll answer Susan's question about speaking at parishes. We actually speak at parishes across Long Island. What I'll do is I'll send you an email and let you know when we're having our next presentation. Thank you, everyone, for joining us. Thank you, Maria Elena and Ashley and Mark, for really a wonderful, wonderful presentation. It was so full of information. If anyone would like to contact me, if you have additional questions, you can send me an email and I'll make sure we get back to you. Thank you so much. Have a great day, everyone.
Oh, Barbara, one other
Yes.
thing, can we just remind everybody to do the survey?
Oh, yes, I'm so sorry. Yes,
That's great.
please, really to help us to know what type of seminars you'd like to hear, please fill out the webinar survey. We would really appreciate it, and it will pop up on your screen.
Yes, and Christine, the slides will be sent along with the audio of the program. We
Absolutely.
just had another question. All righty, thank you, everybody. Have a great day.
Thank you. Bye-bye
you.
now.
Thank you.